Hello everyone, it's Tuesday. Welcome to Tax Law Tuesday. And as we begin, I want you to pay attention to two provisions of the Constitution on matters tax. The first one is Article 210, Subarticle 3, and it says, no law may exclude or authorize the exclusion of a state officer from payment of tax by reason of the office held by that state officer or the nature of the work of the state officer. Then Article 201. One of the principles of public finance is that the burden of taxation shall be shared fairly, and a waiver or exemption from taxation must be legislated and must also be reported to the Auditor General. Now, we are borrowing from a judgment that was delivered this year by the Court of Appeal. The sitting judges were Justices Nyamwea, Ali Aroni, and Achode. Now, in the beginning of the last decade, when we had a prime minister, when we still called them permanent secretaries, when ministers, we still call them ministers, were appointed from members of parliament, when they were 40 in number, when we had assistant ministers who were equally 40 in number, so you have 80. Hey, the head of civil service and secretary to the cabinet then, and you can Google and look them up, they're not in government now, but they make decisions that then just haunt people for years to come. This person issued a directive to the permanent secretaries that all taxes paid by the ministers and the assistant ministers, as demanded by KRA, be settled by the government from the public resources. Okay? And that all deductions that had already been made up to that point be refunded by those permanent secretaries. This is despite the provision of Article 210, Subarticle 3, and 201. Okay? And when they were making this directive, the Constitution 2010 had already been promulgated. Now, patriots went to court, you and I, to stop this illegality. And so it went through the motions, and now we were before the Court of Appeal. And their argument then was that, noting the provisions of Article 210, Subarticle 3, and Article 201, exempting a state officer from payment of tax is discriminatory and is unconstitutional. Okay? And the aggrieved parties now, the National Assembly, because these were their members, and in fact, certain members of parliament, of course, disputed. And you know, we're talking about a government that has an AG who's a legal advisor and who can tell them, please stop in your tracks, you're wasting taxpayers' money. But yeah, we have seen that some of these appointments are just ceremonial. The argument was this, that the Constitution has just come into force. We haven't even had a general election under the Constitution. How about we table this discussion for after the 2012 general elections, because we have a sixth schedule of the Constitution which allows for a transitional period. And so now the Court of Appeal had to go and look at this sixth schedule to figure out if all the provisions of the Constitution were supposed to come into effect after 2012, or some came into effect immediately the Constitution was promulgated, and what have you. So typically, the transitional and consequential provisions of a law provide for a transitional period, because it is understood when you make a change to a legislation, when you make a change to procedures, it can't happen overnight. Certain things can be implemented overnight, others may need a transitional period. And so it is always important for a law, for a bill, which then gets passed into law, or a constitution in this case, to have that provision, to give room for progressive realization of certain things. And so the court said, okay, when we look at the sixth schedule of the Constitution, we see very specific mention of certain articles which are supposed to come into force after the general elections. And now this is a challenge to you. This is a challenge to you to go and look at the sixth schedule and see which ones were supposed to come into effect immediately after the Constitution was promulgated and which one had a transitional period. And the Court of Appeal said If the intention of the makers of the Constitution was to make sure Article 210 sub Article 3 fell within those ones that had a grace period, then nothing should have stopped them from including Article 210. But as you will note, this article is not provided, and therefore the interpretation is that people start paying taxes immediately and you're not exempt just because you hold a state office. Okay? And if that then is the case, the directive issued by the then head of civil service and secretary to the cabinet was null and void. So again, as we plan to vote, just remember these people really make so many decisions that affect you. And this is just my role in the way we think about our responsibilities as citizens, the power that we wield, even though sometimes it feels like it is difficult to achieve change. But when you actually critically think of the people we put in power and the ripple effect that then has in our livelihood, it affects every aspect of our lives. That's what the Court of Appeal said regarding this matter on tax, and it is the living position. State officer, everybody in this country has to share the tax burden fairly. And you're not exempt just because you're a state officer. And every time there's an exemption, it should be based on legislation. The Auditor General should be informed. So that marks the end of today's Legal 101. Let's meet tomorrow for family law. Bye.